everyone, I'm Wong Jia Huey and I have four secret agents with me. They are Amir, Audrey Ng, Kelvin Chia, and Chloe Tan. So now I'm going to start off with the introduction. The ability of a mortgagee to seek for the sale, possession, or foreclosure of a mortgagor's property has long been subject to debates among lawyers, academicians, and critics alike. Of particular interest is whether a mortgagor is offered sufficient protection in these areas so as to strike a balance between the protection of the interests of both the mortgagee and the mortgagor. This work aims to discuss the extent to which such balance has been successfully struck in light of the recent developments. Before discussing can begin regarding whether the rights of a mortgagee and a mortgagor have been balanced, it is first necessary to clarify what a mortgage is. For this, reference may be made to the words of Justice Lindley in the case of Stanley and Wow. He defines a mortgage as a conveyance of land as a security for the payment of a debt or the discharge of some other obligations for which it is given. Such security is subsequently redeemable upon the payment or discharge of the relevant debt or obligation. The rationale behind the existence of mortgages is a pragmatic one. On one hand, it provides a mortgagee, which is a lender, with income in the form of payable interest. On the other, it affords the mortgagors, which is the borrower, a relatively economic and efficient way of turning their immovable asset into a liquid one. In recent years, the mortgage has come to the fore as the major device by which individuals may finance the purchase of a property. In essence, this is done through procuring a loan from a financial institution in order to buy property, with that property itself acting as security for the loan. These are known as residential mortgages. Besides that, there are also mortgages born out of the need to procure capital in order to enter into some form of business venture. These are known as commercial mortgages. There are also various other reasons one might choose to mortgage their property for, such as to financially support a sick relative or to send a child off to the university. Regardless of the motive behind the mortgage, however, it remains a necessity that a mortgagee be offered protection should a mortgagor default on their payments. These protections manifest themselves in three main forms: a mortgagee's right to possession, right to foreclosure, and the right to sell.
Typically, in attempting to realize his security, the mortgagee will seek to sell the mortgage property. However, interested parties would typically want the property they seek to purchase to be vacant. After all, very few purchasers would be interested in procuring a property with a family of four inside it. Hence, in order to maximize the value accrued from exercising his right to sale, the mortgagee would first want to seek possession of the property. It must be emphasized that the right of possession is, as its name implies, a right and not a remedy. This means that a mortgagee may exercise his right to possession the moment the ink is dry on a mortgage, as colorfully put by Justice Harmon in the off-cited Formades case. The effect of possession being a right of the mortgagee means that a mortgagee may take possession of the land at any time, even if the mortgagor is not in default. Further, although it is common practice to obtain an order for possession from the court, it is by no means necessary. This is true for all legal mortgages, albeit not equitable mortgages, where an order of the court is required. Taken at its face, the existence of the right to possession can easily be construed to be a powerful tool to be used by lenders in order to oppress borrowers. Indeed, very few legal barriers appear to prevent a mortgagor from taking possession of a land. However, in reality, the right to possession is rarely exercised. Here, it is important to remember that a mortgagee's principal concern is to ensure that the mortgagor makes regular payments. It is not in the mortgagee's interest to take possession until there is a default on such payments. And even then, the right to possession is typically only exercised as a prelude to sale. Nevertheless, statutory restrictions of the mortgagee's right to possession present themselves in Section 36 of the Administration of Justice Act 1970, as amended by Section 8 of the Administration of Justice Act 1973. Under Section 36, as amended, an application by a mortgagee for possession of a dwelling house may be suspended, adjourned, or postponed by the court in its discretion if it appears that the mortgagor would be likely to be able to pay within a reasonable period any sums due under the mortgage.
The intention of Parliament behind introducing such a provision was clearly to provide assistance to a mortgagee who found himself temporarily in difficulty. Indeed, at first glance, this provision appears to vest the courts with wide discretionary powers, which it can use in providing struggling mortgages with a saving grace. However, this provision is not without its limitations. Firstly, it is meant to be applied to dwelling houses. Whether a premise constitutes a dwelling house is a matter to be interpreted by the courts, taking into account the state of the premise at the time the court order is sought. Clearly, this means that this provision is meant to be applied to residential homes, and hence cannot be used to protect commercial mortgages. Secondly, is the meaning behind a reasonable period. A reasonable period, in this case, may well extend to the end of the mortgage term, hence affording considerable leeway to the mortgager. However, Section 36 may not provide protection to a mortgager who, by reasons of financial hardship or overcommitment, have no real prospect of being able to repay his debt, let alone in a timely manner. Section 36 may also not be used in situations where a court order is not sought. Here, attention must be drawn to the status of the right to possession as a right of the mortgagee. There may be situations, though rare, where a mortgagee decides to take possession without a court order, something which, as alluded to earlier, he is perfectly entitled to do so. In such a case, Section 36 is inapplicable, and therefore the court has no jurisdiction to control or suspend the possession. Finally, Section 36 may only apply when a mortgagee seeks a possession order and not a purchaser. Consequently, in situations where possession is not sought, but the right of sale is exercised, a mortgagor cannot seek solace in the protection offered under Section 36. This is illustrated in Horsham's Properties and Clark, where the provision was successfully sidestepped in this manner. Aside from the statutory restrictions discussed above, the courts have been seen to utilize alternative means of keeping a mortgagee out of his right to possession. This was demonstrated in the case of Cornell and Maltby, where Lord Denning suggested that a court of equity could restrain a mortgagee from taking possession whenever there was no justifiable reason for that possession. Though most of these avenues are either narrow in scope or arise in special circumstances, it demonstrates the judiciary's determination to prevent the abuse of the right to possession. Overall, it can be seen that the seemingly overbearing potency of the mortgagee's right to possession has, to an extent, been watered down both by practical and statutory limitations. Notwithstanding this, the statutory limitations themselves, though appearing to confer the court's sizable discretion to protect mortgagors in financial hardship, are also subject to limitations of their own. This calls into question whether an appropriate balance has been struck between allowing for the mortgagee's right of possession on one hand and protecting mortgagors from oppression on the other.
As alluded to earlier, a mortgagee has the power to sell the mortgage property in order to recover the sum owed. In most circumstances, this will be expressly contained in a mortgage. However, in the absence of such a clause, a power of sale will be implied into every mortgage made by deed by virtue of Section 101, subsection 1, subdivision 1 of the Law of Property Act 1925. unless a contrary intention occurs, as illustrated in Swift First against Cole. In order for the mortgagee to be able to exercise his power of sale, the power of sale must have a reason and must also become exercisable. A power of sale arises when the legal date for redemption has passed, provided the deed does not expressly exclude the power of sale. This power then becomes exercisable upon satisfaction of the conditions specified under Section 103 of the Law of Property Act 1925. This provision requires either notice requiring payment of the whole mortgage sum to be served by the mortgagee, and that the mortgager is 3 months in arrears after such a notice, or that the interest under the mortgage is in arrears and unpaid for 2 months after becoming due, or that the mortgager has breached some provision of the mortgage deed or a relevant position of the LPA 1925. The act of exercising the power of sale is a drastic one, particularly when the mortgage property is a residential home. This is because it has the potential to leave a family homeless. As such, considerable protections have been put in place so as to secure this power is exercised properly. Firstly, limitations have been put in place against mortgagees seeking to sell the property before the power of sale has arisen. In such a case, the purchaser of the property obtains only the mortgagee's interest and the mortgagor remains unaffected. Additionally, if the mortgagee sells the property after power to sell has arisen, but before it has become exercisable, the purchaser takes the land free of the mortgage. However, the mortgagor may still be able to set aside the sale, provided that the purchaser had notice of the mortgagee's fault, as stated in Section 104 of the LPA 1925 and seen in Cookmere Brick Call against Mutual Finance. Aside from that, Section 91, Subsection 2 of the Law of Property Act 1925 allows the court to make an order of sale at the request of any person interested in the right of redemption. As such, it is not only the mortgagee who can exercise this power, but also the mortgagor. This is particularly valuable to the mortgagor in situations where the mortgage property is worth more than the outstanding mortgage and payments. In essence, it allows for the mortgagor to crystallize his immediate liability, in addition to ensuring the best possible sale price is achieved. The importance behind maximizing this sale price is found in Section 105 of the Law of Property Act 1925, which provides that the surplus from the sale is to be paid to the persons entitled to the mortgage property. Most of the time, this is the mortgagor. Ultimately, it is hopeful that the surplus will dampen the blow of the loss of property towards the mortgagor. With this in mind, the court, through its equitable discretion, has taken to regulate the conduct of mortgagees to ensure this. Among the steps taken is compelling the mortgagee to take reasonable care to ensure that the best price reasonably obtainable at the time is obtained. The mortgagee is not entitled to act in a way which unfairly prejudices the mortgagor by selling hastily at a knockdown price sufficient to pay off the debt, as was held in Sylvan Properties Limited against Royal Bank of Scotland. As such, the mortgagee may decide that the timing and manner of the sale, but will be liable to the mortgagor if he fails to act within reasonable care to obtain a proper price. The liability owed to the mortgagor would generally be in compensation for the difference between the price obtained and the true price reasonably obtainable. However, it must be reiterated that the mortgagee need only take such steps to ensure the best price reasonably obtainable at the time. This may be satisfied simply by holding an open public auction, even if the current prices are low, as seen in Cookmere Brick Call against Mutual Finance Limited. However, where this course is not pursued, the court will take consideration of the steps which the mortgagee took in order to sell the property, and whether that was sufficient in obtaining the best price.
It can hence be seen that the mortgagee must behave as a reasonable man would behave in the realization of his own property, so that the mortgagor may receive credit for the fair value of the property sold. Besides that, to protect from possible conflicts of interest, the mortgagee may not sell the property to himself, his agents, or his employees. Further, in the event that the mortgagee sells the property to a company that he has an interest in, or he is even associated with, the burden of proof that the sale was at the best price reasonably attainable lies with the mortgagee. If the mortgagee fails to discharge this duty, the mortgagee would be held liable, as seen in the case of Mortgage Express in Mana. This is done so as to ensure that a mortgagee cannot simply sell off the property without consideration of their duty to obtain a reasonable price.
Based on what has been discussed, one would be forgiven in thinking that the law has sought to heavily fetter the mortgagee's power of sale. However, this cannot be taken as the law picking favorites. After all, just as it is important to ensure that the power of sale is not used lightly, it is equally important to ensure that a mortgagee is able to recover debt owed to him without unnecessarily burdening him. Indeed, protections have been extended to the mortgagee to mitigate the oppressiveness of the law towards their power of sale. Firstly, the duty imposed on the mortgagee is to take care to preserve and not increase the value of the property, as seen in McHugh and Union Bank of Canada. This means that a mortgagee need not take such steps as an owner might to increase the selling price of the property, such as pursuing planning applications, granting leases, or selling certain fixtures separately. The mortgagee is also afforded a certain margin of error in selling the property. The mortgagee will not be deemed to have acted wrongly unless he is plainly on the wrong side of the line, and the margin for error afforded appears to be large, with one case accepting a range of up to £300,000. In short, it can be seen that the mortgagee's power of sale, though potent in theory, is subject to many limitations which ensure that this power is not exercised lightly, and that the mortgagee's rights are safeguarded. With that being said, however, the law tries not to encumber the mortgagee with unnecessary hardship and offers leniency provided they have acted reasonably in seeking repayment for the debt owed to them.
The right to foreclosure is regarded as the most powerful remedy in the arsenal of a mortgagee. It allows the mortgagee to enforce his rights to possession of the property and extinguishes the mortgage and its terms under Section 88 of the Law of Property Act 1925. In essence, it allows for the mortgagee to obtain the mortgage land free from the encumbrances of the mortgagor's right. This right arises once the legal date for the redemption is passed, although it is common for the mortgagee to promise not to foreclose without notice. Generally, foreclosure proceedings begin with the mortgagee bringing an action to the court, requesting for the foreclosure unless the mortgagor repays the mortgage within a stipulated time. If the repayment does not occur, the court will grant the mortgagee a foreclosure order which, in effect, gives the mortgagor a further period in which to raise the money to pay off the loan. Failing to do so will make the order of foreclosure absolute, and the mortgagor's interest in the property will be extinguished. Hence, in essence, the court can provide the mortgagee with the right to take over the entire ownership of the property, irrespective the size of the debt owed to him. The underlying objective of obtaining an order of foreclosure is to obtain the property in order to sell it and subsequently recover the debt owed. However, the ability of the mortgagee to retain all proceeds from an auction or sale is certainly an overbearing one, particularly in situations where the property sought to be foreclosed is significantly more valuable than the debt owed to the mortgagee. Indeed, the courts appear to share a similar sentiment, preferring to instead issue an order for sale in lieu of foreclosure under Section 91, subsection 2 of the Law of Property Act 1925. Consequently, and as acknowledged by Sir David Nichols in the case of Park against Mortgage Services Funding, foreclosure actions are almost unheard of today and have been for many years. The Law Commission has also recommended to abolish the right to foreclosure and to replace it with a remedy for the mortgagees to sell the property to themselves. In short, the right to foreclosure, so once the most powerful remedy afforded to the mortgagees, has largely been relegated to redundancy. Clearly, the courts have recognized its overbearing nature and the potential for the oppression towards the mortgagor. Hence, in order to protect the rights of the mortgagor, they have taken to issuing an order for sale in lieu of foreclosure. And now, I will be talking about the law in light of current circumstances, which is the COVID-19. The COVID-19 pandemic has presented adverse and wide-reaching consequences. National economics have depressed, and whole industry have been rendered to a standstill, with the financial and housing industry being no exceptions. The legislature in the UK have deemed it fit to grant an extended period in the relation to possession proceedings with the aim of affording mortgagors more leniency on mortgage repayments. Under the Coronavirus Act 2020 Residential Tenancies Protection from Eviction, Amendment England Regulation 2020, notices served under Section 8 of the Housing Act 1998 between 29 August 2020 and 31st March 2021 require a minimum notice period of 6 months. Additionally, Controls on mortgagees' right to possession have been put in place through limitations on the period in which they may start possession proceedings. This is seen in Part 55 of the Civil Procedure Rules, which was amended by the Civil Procedure Amendment Number 5, Coronavirus Rules 2020 Rules, to delay possession proceedings by the mortgagees. Here, it is provided that the possession proceedings that started on or before 19 September 2020 are to be stayed until 20 September. This also applies to application for a possession order. Furthermore, the amendment to the Section 21 4D of the Housing Act 1988 has extended the period in which the landlord can start possession proceeding from 6 to 10 months after the service of Section 21 notice. Besides that, the Financial Conduct Authority (FCA) provided further protection for homeowners by stating that a mortgagee cannot repossess a residential property until after 31st of October 2020. It is also provided that, should it be required, mortgagors may request a 3-month payment deferral before 31st of October 2020, which is usually granted by the mortgagee. It can be seen that, in light of the pandemic, great dynamisms have been displayed in the legislature shift response to the current circumstances, so as to ensure that the mortgagors and their livelihoods are protected. This goes to show that, if need be, legislatures and most likely the courts will step in to afford necessary protection to the mortgagors. However, that this is not to say that only the mortgagors' rights are to be protected. Through the measures adopted above seem to afford more protection to the mortgagor, the mortgagee's right to sell and possession have not been extinguished through these steps, merely delayed. Thus, it is clear that the English legislature has sought to balance the rights of both parties, even in these trying times.
In conclusion, the mortgagee's right to possession, sale, and foreclosure are ones which bear considerable potency. As such, the courts and the legislatures have attempted to dilute such powers in the interest of protecting mortgagors while also keeping in mind the interests of the mortgagees. Upon investigation of the measures taken, it is submitted that an appropriate balance has been struck between the rights of these parties. Moreover, the present COVID-19 pandemic has allowed for a glimpse into the willingness of the legislatures to act swiftly in implementing corrective measures should this balance be disturbed. This balance struck between the rights of the mortgagor and the mortgagee, along with the readiness to adapt the extrinsic circumstances, is ultimately the reason upon which we argue that the present law is indeed satisfactory. That's all for our presentation. Thank you for watching.